Now let's take the next important subject. What do you do when free speech becomes the tool, a weaponized tool for an attack on the existence of a certain state? What do you do then? As I said, again, ideological positions may lead to different conclusions on this particular issue. If you are a person who believes that it is the existence of the state that allows you to enjoy these rights and live with freedom or in freedom, then an attack on the state is not permissible, because the existence of the state is much more, let me say this with a bit of sanctimony, that it is much more sacrosanct, it is much more sacred than perhaps even religion itself. If the state does not exist, that political entity does not exist, and the thought behind the creation of that political entity does not exist, and it is subjected to attacks from all corners, then effectively the geography within which these rights are being enjoyed is under threat. And that is the single biggest reason that an attack on the state and a call for the dissolution of the state, according to me, is impermissible and justifies the existence of a sedition law. Whenever I discuss this particular issue, the standard argument, the unimaginative argument, and the predictable argument, and the thoughtless argument, and the ignorant argument, and the uninformed argument that I get is, no, sedition was effectively used by the British to gag Indians. How can we follow that? We have anyway thrown off the colonial yoke, so why are we following this? Okay, good argument. So there are two problems with that particular argument. So let's take another example. The Arms Act was implemented by the British to take the weapons away from Indians so that they are not in a position to give violent resistance or armed resistance. Since that is a British import, shall we revoke the Arms Act? And shall all of us have weapons? Why do we need a licensing structure? We certainly have an example, as far as America is concerned, where people have the right to bear arms. So that particular legislation or that particular jurisdiction which we constantly look up to for free speech and other rights seems to justify the right to bear arms. So should that be the argument? The question or the issue whenever it comes to these kind of questions is, you don't kick something out merely because it has come from someone or it has been imposed by someone. You question its existence and its need based on relevance in the circumstances you live in. If the Arms Act is a necessity today, it shall continue. But if the Arms Act becomes unreasonable because you do not have enough policemen or policewomen to protect you, and the state is no more in a position to protect your individual liberty or civil liberties, then perhaps its existence must be questioned. Because one of the principles on the basis of which a legislation exists or does not exist, even if it is in the paper book or let's say in the statute book, is this maxim called cessat ratio cessat ipsa lex, which means the moment the reason for the existence of a law ceases to exist, the law itself ceases to exist, notwithstanding its presence in the book. So when you look at sedition law, you should ask yourself, is this a certain piece of legislation or section 124, does it bear any kind of relevance? Does it warrant an existence as far as India is concerned? It is my opinion, my humble opinion, but certainly a firm opinion, that given the kind of forces at play and given the kind of pulls and pushes that Indian state is currently subject to, and given that it is in a phase of transition, which I think is going to last for some time, for the foreseeable future, and this is an extremely crucial phase for this country, the civilization, that law needs to exist, is my opinion. Now, as far as the legal position is concerned, in 1962, which is 15 years after independence, the sedition law was challenged before the Supreme Court. And the Supreme Court had an opportunity to consider whether in light of the Constitution, whether in light of reasonable restrictions as far as free speech is concerned under Article 19, does this particular law justify its own existence? And the court has come out with a very clear test. One, the first conclusion being, of course it is relevant and of course it must continue. However, it strikes a distinction between the state and the government. it is absolutely fair game to hurl almost any kind of allegation against a government. I have even reservations on that, but then since I'm a free speech absolutist on that particular front, I think it's fair game. But if it is going to be somebody's argument that the Indian state deserves to wither away, or it deserves to perish, or it deserves to be dissolved, or it deserves to be destroyed, or whichever synonym you wish to use in whichever language, that is where the red line has been crossed. So somebody could say, aren't you being mighty convenient in your position that you say that when it comes to religion, the red line is a bit too long, but when it comes to the state, your sense of tolerance or your sense of patience, your sahishnata is in serious question. According to me, different topics deserve different treatments. And to treat all of them at par with each other would be to treat unequals equally, which is another form of inequality. The sandarbh will effectively decide the outcome and your approach. And if you say that it needs to be uniform, then effectively you have translated in your own heads that equality is equal to uniformity, which is not what it effectively means. So as far as free speech is concerned, I think Section 295A, the provision that prevents a lot of people from saying what they wish to say with respect to religion or religious figures, its time has come, it needs to be junked, it needs to be jettisoned. That is my position. And hopefully that will happen someday when there is a review or a reconsideration